Hey everyone, it's Rob Ryder on Monday, the 28th of January 2013. And if you were to go to TalkShoe and put in caller ID 122402 up here in this little box, it says caller ID, you would come to this page taking clues from ancient books. TalkShoe I had set up. And if you were listening to the call, it was on 1/24/2013. Where I was talking to Bob in Pennsylvania about his day in the Court of Common Pleas for foreclosure. That was a trial. That wasn't a hearing, that this was a trial. And it ended up being adjourned. And so we're going to talk about that a little bit. A couple of things that Bob had told me earlier that after listening to it a couple times, I didn't hear that we had said it, was that when they were in the pretrial conference in the back judge's chambers, and Bob was bringing up the fact that the plaintiff had not signed the complaint, the judge was a little exasperated or whatever, and he said, well, why are you now just bringing this up? And of course Bob said, well, I just now figured it out, right? So again, this foreclosure has been going on for 2.5 years, and Bob's talking about the original complaint 2.5 years ago not being signed by the plaintiff. And he also mentioned that in the court, unlike in Roe's hearing that she had, where the bailiff or sergeant at arms or whoever it is that calls people in made an announcement that the circuit court clerk was in the courthouse, and sure enough, the circuit court clerk was in the courthouse during her hearing. And Bob said that in his hearing there was no circuit court clerk, just the judge's clerk. So interesting. Again, I think that the circuit court clerk represents the chancery, the Vatican, whomever. And again, this is based on some guy in Santa Fe on a call I did 1.5 years ago who had stopped in just to go ask some questions. The circuit court clerk asked her, he said, I believe that your oath is held by the bishop. And she said he was right. So that's the circuit court clerk. Don't know about anybody else, but I think that he represents the chancery. And something else that Roe pointed out that's kind of interesting, they had this big judicial building, has 2 addresses. One is 230 Elm Street, let's say, and the other one's 240 Elm Street. One half is the clerk's office, the other half is what does she call it? Judicial division, some kind of committee building. Well, when you go and look in the city to see who can do business in the city, building 240, the clerk's office has a license to do business in the city. Building 230 does not. It looks like one big building, has 2 different addresses. It's 2 different buildings. And the one building has a license to do business in the city, and the other one doesn't. The one that does is the circuit court clerk's office. Okay, so this is what happened to Bob. I gotta close some of this stuff up, or I won't be able to keep track. Okay, so Bob had his case, and then this weekend he got this paperwork sent to him, and he kind of messed it up when he put it in here, but let me flip this over. Okay, so as far as you know, the case ended adjourned. An adjournment, the dismissal by some courts, legislative assembly, or properly authorized officer of the business before them, either finally, which is called adjournment sine die, without day, or to meet again at another time appointed, which is called a temporary adjournment. Now, when the guy adjourned the case, from talking to Bob, he didn't say, hey, we'll meet again on Tuesday, or gave a date. He just kind of what he had said. They were looking at Bob's exhibits, and one of them was the deed of revocation, to revocate the deed of trust. It was Exhibit 3. It had that in the notice he had sent to the bank in Exhibit 3. And so the attorney for the bank, or not even for the bank, but just the attorney, said, well, we would have a objection to exhibit number 3. And then the judge says something to the effect, well, you'll have my decision on that in a few days. This case is adjourned. To that effect, right? So he adjourned it. He didn't say that he agreed with her objection. But the case was adjourned and there hadn't been a day set for trial. So, with that being said, then we look at what he did. So this came to Bob on, I guess he got it late Saturday. Sent it to me yesterday. And this is a verdict and judgment. And now, this 24th day, January 2013, following a non-jury trial held in the above captioned case, and after thorough review of careful consideration of all pre-trial and trial memoranda, trial testimony, and exhibits, it is hereby ordered and decreed that a verdict will be and hereby is entered in favor of the plaintiff, City Mortgage, and against the defendant in the amount of $182,000 and change, interest, cost, charges collectible under the mortgage for foreclosure and sale of the mortgage property. It is further ordered and decreed that an in rem judgment will be and hereby is entered in accordance with the foregoing verdict. So at first blush, you say, that's pretty bad for Bob. Right? Let's go look at some of these words. First of all, looking at the page, why is verdict sticking out like a sore thumb, and why is judgment? That's why it's always good to go and look at the definitions, because you'll see a verdict is the unanimous decision made by a jury. But wait, it was a non-jury trial. Well, if it's a non-jury trial, there can't be a verdict. There wasn't a jury. That would be a procedural error. And the judge knows this, and he's doing it on purpose. And then decreed. So what's a decree? The judgment or sentence of a court of equity. It has the same effect as a judgment at law. But down here he called it a judgment. Well, judgment is what's used in law, and decree is what's used in equity. He's mixing two forms of court here. Nevertheless, there wasn't a verdict because there was no jury. And he's saying here that an in rem judgment will be, an in rem would be against the res, the subject matter, but not in personam, not against the person. So, there's reason for procedural appeals. Now the other one is, I don't see the clerk stamp on this. Now Bob said there was a stamp on one, but wait till we get to the order. Okay, so he also issued 2 orders. Let's go to the one that went to the case first. So this one goes to the foreclosure case. Remember, there's 2 different cases here. Bob was in a foreclosure, and he had put in a responsive answer. But also prior to that, when we were just starting to play around with this, he put in a civil action looking for, basically a declaratory judgment or some kind of complaint in equity. Because of the situation he was in, that they hadn't signed the deed of trust, the promissory note's actually a security, there are no recorded liens. To try to enforce an unrecorded lien is unconstitutional, and that would be warned with the Constitution, and that could be and is construed as treason. So those were the kinds of things he was bringing up in his defense. But the judge decreed what he decreed, and then he issued this order. And now, this 24th day of January 2013, upon consideration of plaintiff's motion for summary judgment and defendant's answer to complaint invoking equitable defenses thereto, as well as memorandum of law submitted in support thereof, it is hereby ordered and decreed that said motion will be and hereby is denied. So they denied the city mortgage's motion for summary judgment. It is further ordered and decreed that defendant's counterclaim will be and is hereby denied. So he denied the counterclaim and he denied their motion for summary judgment. Well, okay, that was the order to. This is what the order says to do, right? To revoke the summary judgment. Okay, now what I want to look at from here. Let's go back up here. Okay, and then here is the other one. Now this case here is the case number for Bob's civil action that he put in, basically claiming the same things he had claimed on his counterclaim in his responsive answer, which was the bank didn't sign the deed of trust, there was no contract, it's a security instrument. On the security instruments listed the securities. One of those would be the promissory note. And the promissory note is actually a security because it has a matures greater than 9 months out. So it's always been a security. It's never been a promissory note. From the day it was written, it was a security. Doesn't matter what the title is. It matters what the paperwork does. Doesn't matter they call your deed of trust or mortgage what they do. What matters is what it says it does. And it very clearly says it is a security instrument. If it's a security instrument, it cannot be the lien. The lien is another piece of paper. You would put a lien against the security instrument. And so they're supposed to take your deed of trust and do a UCC1 filing with the Secretary of State, or file with the Secretary of State the deed of trust. Well, that isn't where they file the deed of trust. They file the deed of trust with the Register of Deeds. That isn't where it's supposed to go to be seen as a lien. To be a lien, it's a UCC1 filing. This is out of the Uniform Residential Mortgage Satisfaction Act. However, upon consideration of plaintiff's complaint and injunctive relief, both of which arise the same nucleus from this other court case, again, a non-jury trial which resulted in a verdict. Well, non-jury trials cannot result in a verdict because a verdict comes from a jury. In favor of the plaintiff, it is hereby ordered and decreed the above captioned case will be and hereby dismissed as moot, and Office of Judicial Support will be and is hereby directed to make this case discontinued and ended with prejudice. Okay, so we need to look at a few more definitions. So what is moot? Dismissed as moot. A moot question is one which has not been decided. If you ask a question which has already been asked by someone else, but to which there is not yet an answer, then your question can be dismissed as moot because it is redundant. I think all the judge is saying here is he can dismiss this case because Bob's already asked the questions on the other case on again, this is the foreclosure case here, and so he put in a answer to this, and it was denied based on this verdict judgment, which has procedural errors. But on the verdict judgment, read it upside down. In rem judgment, right? So the court's saying that they have jurisdiction over the title to the land, to the property, to this 182,000, right? They have the jurisdiction to that. They don't have the jurisdiction in persona. Well, they don't, because these are coming out of a civil action in law, and we're trying to get a civil action in equity. So they intentionally leave a bunch of holes um, in my opinion, for you to appeal. Now, if you look at this order and compare it to the one that Roe got, here's an order from a judge, and this one's got, right? It's got the clerk of the circuit court, Kane County, Illinois. Right? This is the civil action that Roe opened, and they had a hearing. It had to be continued, and so the judge wrote an order for continuance, and the clerk of the circuit court put his seal. But you don't see that on here. And let's look at, see, I don't think that this signature block by the judge is going to make it. We're going to find out there's a few other things missing in here. Let's see. What do I want to look at? Where was that? Oh, just too many pieces of paper to remember. Hang on a second here. Civil action, Pennsylvania. Mail. Oh, let's see what this Rule 236 says. Ah, this is what I wanted to find. So, if we go back and look, because there was more paper here. So, Delaware County, Pennsylvania, Office of Judicial Support. Notice is hereby given under PA Rule of Civil Procedure number 236 that an order in the above cause has been entered the 25th of January 2013. Well, what is this Rule 236? It says, notice by protonotary of entry of order, decree, or judgment. When filing any order, decree, or judgment, a party shall list on the document the name and address of each attorney of record and each unrepresented party. Okay, has to list the name and address of each attorney of record and each represented party. Well, let's go look at that judgment. First of all, here's the order. I don't see any addresses for anybody. Never fails. Let's see if this one had any. Here's another one. I don't see any addresses. Don't see any attorneys listed. No attorneys of record are listed. So it wasn't done per procedural rule 236 is my point, right? It's another procedural error. And that's what the Court of Appeals is for. If there's a procedural error and you bring it up to the Court of Appeals, they'll overturn the case. So, good stuff. Good stuff. Let's see. We don't want to go there yet. Let's see what other. Okay, so a judgment. A judgment, the decision or sentence of law. The language of judgments, therefore, is not that it is decreed. However, and having this one page the wrong way is making it very difficult. However, I could swear that someplace, oh, it is decreed, right? Well, it's supposed to be a judgment, and it's decreed. It is further ordered and decreed that an in rem judgment. Well, judgments, it should be, it is considered, not it is decreed. To be valid, a judicial judgment must be given by a competent judge or court at the time and place appointed by law and in the form it requires. in the form it requires. Well, we saw by Rule 236 it's not in the form it requires. A judgment would be null if the judge had not jurisdiction of the matter, or having such jurisdiction he exercised it when there was no court held, which he did, or but of his district, or if be rendered a judgment before the cause was prepared for a hearing. Anyways, it's not a valid judgment is my point. There are four kinds of judgments in civil cases. When the law is admitted but the facts are in dispute, as in a case of judgment upon a verdict. Well, he said there was a judgment upon a verdict, but the verdict didn't matter because there was no jury. Because that's what juries do, is they hand down a verdict. Judgment in a sum is either in favor of plaintiff or defendant. When in favor of the plaintiff, it is for him to recover a specific sum assessed by a jury, or on reference to the pro notary or other proper officer for the damage which he has sustained by reason of defendant's non-performance of his promises and undertakings, and for full cost of the suit. Well, that kind of sounds like what he was given these guys here. There's the amount of the damage. It's a money amount. It's a money damage plus interest and other costs and charges collectible under the mortgage. That's what he was. So it sounds like it was a judgment in a sump sit. Anyways, this is the definitions of judgment out of Bouvier's, and as you can see, it goes on and on and on. The judgment is interlocutory and assumped when the sole object of the action is damages, but in debt, damages not being the principal object of the action, the plaintiff usually signs a final judgment. So this looks like it was for damages. The sole object of the action is damages. So in interlocutory, this word is applied to signify something which is done between the commencement and the end of the suit. So this is saying it's not the end of the suit yet. This is a midway point if the judgment is interlocutory and assumped for damages. It seems to be what it is, but again, doesn't matter because I didn't follow procedures. So all these great things are written for law that if they're doing it correct, you would have to deal with, but you always point out their error first and see their last. And so none of this was by Civil Rule 236 filed for record. Because a final judgment is the one that puts an end to the suit. That's what we're trying to get to, but we ain't made it yet. And an interlocutory judgment is one given in the course of the cause before final judgment. So we're not at final judgment yet. That's because you still have an appeal. Really, we're just dealing with a judge of first instance right now, and there's a judge of second instance, and there's a judge of third instance. It would normally be the bishop, the archbishop, and then the pope. To a certain such damage, it is a practice to issue a writ of inquiry when the action is founded on a promissory note, bond, or other writing, or any other contract by which the amount due may be readily computed. The practice is, in some courts, refer to the protho notary or clerk to assess the damages. Okay, so anyways, there's 50 some definitions in judgment, right? So we're not going to go through them all. Look at that. 55, 56, 57 different chapters on it. What's in rem? A technical term used to designate proceedings or actions instituted against the thing in contradiction to the personal action which is said to be in personam. Chancery equity is in personam jurisdiction, right? Law is against the thing. Law has jurisdiction over the thing because in law, he who holds the legal title is the owner. We don't hold the legal title to anything. We may have equitable title, we don't have legal title. However, since we have equitable title, if we bring a claim in equity for the legal title, because it was gotten by fraud or bad faith or whatever, and they find in your favor, they're going to go get you your legal title. And that's really what we're trying to do, get our legal titles back. Courts of arbitrary enforce the performance of a contract by seizing into their custody the very subject of hypothecation, for in these cases the parties are not personally bound and the proceedings are confined to the thing in species. I really think that that's what they're talking about. I, the judge says he has jurisdiction over the thing. All right, because he put an in rem judgment in. And in rem would be over the thing. So I think he's saying he has jurisdiction over the thing in this court, civil action and law, but not in personam jurisdiction. And since technically the bank has the legal title, he should be given the property to them. So we need to go in and put an appeal and say, yeah, but they didn't follow procedures and they didn't sign the complaint, and I claim that it's my property, and all the things that Bob's already done will be in the in his appeal to the verdict judgment of this judge in this case, in which he put all of this information into the court case. So I think the judge is saying, we're going to get rid of the one you put into equity that way, and we'll just take this one. I'll give us some bullshit answers here. If you're smart enough to figure it out and appeal it, we'll let the appeals court handle it. And in Blackstone, they talk about doing this stuff where, judges are lazy. They just put some errors on the paper, and if you find it later, they can say, hey, it was a procedural error. In law, everything must be exact. And I got to find this appeals book that I had found for Roe earlier. But when you understand that in common law, it's all about the form, right? Got to have the commas in the right place, right punctuation, right capitalization, can't leave any words out. Very, very, very precise. And so if your remedy doesn't exactly fit the writ, then a judgment in law is always inferior to a judgment in equity, which only gives justice. If equity follows a law and law is unmodified, then that law they're talking about is God's law. So equity follows God's law, which in my opinion is justice. And therefore, it doesn't care about man's law. It will not allow a statute to be used for fraud. It will not enforce an imperfect gift. Let's see here. So personal jurisdiction. A state must have personal jurisdiction over a defendant in order to impose upon him through its courts a personal liability or obligation in favor of the plaintiff. Well, as far as I'm concerned, again, the court didn't put anything in persona. It just put it in rem. Jurisdiction in rem. Sometimes the purpose of the action is not to impose a personal liability or obligation upon anyone, but to affect the interest of all persons in a thing. All right, so not to put an obligation on the person, but just to affect the interest. In other words, who's got the title? Right, that's the jurisdiction that can decide who has the title. And so where it sounds like this judge has given it to the bank, when we go to the appeals court and they tell the judge to overturn his case and give it to Bob, well then Bob will have the title. It's just that the court that has the in rem jurisdiction is letting the appeals court tell them what to do. If we take it to them and make the right argument, but I don't want to say argument, wrong word. If we go make the right claim. And then they also have a thing called quasi-rem, which really reads the same as this, but it's not to affect the interest of all persons in the thing, but to affect the interest of a particular person in a thing. If so, the state may render through its courts valid judgment when it has jurisdiction over the thing, even though it may not have personal jurisdiction over the persons whose interests are affected. And this would be, to me, quasi in rem, because the paperwork's doesn't have the right seals and stuff on it. It's just fiction paperwork. It's color of law paperwork. Well, quasi in rem is color of law in rem. It's pretend in rem. The jurisdiction quasi rem, like a judgment in rem, affects interest in a thing, but unlike a judgment in rem, affects the interest of only particular persons in a thing, and not the interest of all persons in a thing. It differs from personal judgment, and that it does not impose personal liability or obligation upon anyone. So, there is no personal obligation for you to pay any of this stuff, is what the judge is saying. It's an in rem decision. Nevertheless, because he has the jurisdiction over the title, right? We want the title. We're going to go to the appeals court and have him give us the title and the securities. Okay, so what was this? There are two types of proceeding quasi in rem. In the second type, plaintiff is not seeking to establish a pre-existing interest in the thing, but is seeking to enforce a personal claim against the defendant by applying the thing to the satisfaction of the claim. Of this type of actions to recover damages for breach of contract or for tort begun by attachment or garnishment or creditor's bill, where the state has no jurisdiction over the person of the defendant, but has jurisdiction over the thing belonging to the defendant, and over the person who is in possession of the thing belonging to the defendant, or is indebted or under duty to the defendant. So the court has in rem jurisdiction over the thing, and also jurisdiction over the thing belonging to the defendant, the res, and over the person who is in possession of the thing. Who's holding the deed of trust with the blue ink signature? It ain't you. But the court is saying they have jurisdiction over that person and also over the res, but not over us. And so we need to, we need to get to equity. And I think we're gonna find it when we take it to the appeals court. The appeals court's got 3 judges on it. That's a tribunal, right? This was a single judge, non-jury case, and he handed down a verdict. He did it on purpose, leave some holes for us to appeal. And then this is interesting: the minimum standards of a photo notary's records. This is in Pennsylvania, Bob. Okay. There should be one general docket shall be employed, in which all actions, judgment, liens, and matters, which is federal liens, secure transactions, fictional names, notary docket, power of attorney register, shall be maintained as therefore shall be recorded in chronological order, regardless of type or description, and which shall be recorded as brief as possible. Caption, attorneys, number of case, type of action. Okay, so that's the general docket. And these are things that in the photo notaries, proto notaries records, right? They have one general docket. We want to start asking for these docket books. In rem matters are those actions requiring identification of real estate. Description shall be identified either by recording the name of the record owner, and we're trying to find out who's the owner on the record, or the tax map unit and parcel number indicators established by modern. Okay, so it could do one or the other. We won't know till we go look. And also that they have a manual system, shall maintain a separate locality index. So these are different kinds of indexes, which shall contain the name of either the record title owner, or a tax map unit and parcel number or indicator as established by modern tax identification systems. So getting that information out of these dockets may be something new to go look at, to find out where they're hiding the paper. All satisfaction determinations by parties and entries settled, discontinued, and end shall be accomplished by satisfaction piece and not by entry of signature on docket. And he did a discontinue and end. One of these things here. And this one. Discontinued and ended with prejudice is what he did. They should have a satisfaction piece and not by entry of signature on the docket. The general docket shall have the following index system. It will have a judgment index in which all judgments, liens, and lis pendences shall be recorded. You want to go to the proto notary in the general docket, looking in the judgment index to find out where the lis pendens has been recorded. Right, so this isn't necessarily in your court case in that office. This is in an index they have someplace in the general docket. It's called the general docket. We need to go look at the general docket. Interesting, interesting. So that's where kind of, things are today. Don't really know what all this means yet, but we're just playing around and we're going to see. What I want to show you here. Oh. Yeah, I forgot. Now, in Illinois, Roe found a civil procedure for verification. And basically it says that the plaintiffs have to sign their own paperwork. Everything. It can have the attorneys on there, but the plaintiff has to sign it also. And say that they agree under penalty of perjury, that they've read and understood it and yada, yada, yada. And I'm just showing you on the complaint. So this is the complaint that she has, right? This is the complaint page, last page. It's not signed. This isn't a foreclosure against Roe. That started after she started her action. But as you can see, it's not signed by the plaintiff. It's signed by its attorney. Well, who the heck is that? These little blurbs under here, I think they have to put their office, right? You need a little more information than just that to make these things stick. Let me see what the judge did here. That's the judge. Date. Hard to say. So, but as you can see on this order, the judge, the circuit court clerk, put a seal. And on the one that we got going here, sorry it's upside down, but I'm tired of turning it back over. It doesn't have the seal of the clerk of the circuit court. Lots of holes. So I'm going to get with Bob. We're going to figure out what to write up. We'll send it in on an appeal and see what they do with that. All right, that can go. That can go. That one can go. I guess that's about it. I wanted to show you. Oh, this one I want to show you. Okay, here's a lis pendens. No. Pursuant to Fair Debt Collection Practice Act, you are advised that this law firm is deemed to be a debt collector attempting to collect a debt, and any information obtained will be used for that purpose. Okay, so the attorney of record is a debt collector. He's not working for the bank. Right? He's not an agent of the bank, and either the plaintiff or their agent is the ones that need to be signing this paperwork, and the attorney of record is neither of those. And so that's why they can't sign the complaint and they can't sign the motions by themselves. Right? They have to have the concurrence of the people they're working for, because they're not representing them, they're just their advocate. The in persona means you are representing yourself, and you can have an advocate, but you can't be represented. So, okay. I hope that was helpful, and we'll see what comes up next. Talk to you all later.